5 seconds to go. Start. The High Court relied upon confessional statement recorded under section 164 CRPC and found that the same was voluntary and had been made by the appellant without any threat or fear, and that it contained a full confession of crime and also disclosed the manner in which the crime had been committed. The High Court also relied upon the report of the serologist Shri V.N. Kumar, who had stated in the chemical report that the seized articles, including blood-stained sword produced by the appellant and the clothes of the appellant, were stained with human blood of B group, which tallied with the blood group with which the clothes of the deceased persons were stained. The High Court treated this as sufficient corroboration of the retracted confessional statement, and further relying upon testimony of the sister-in-law of appellant PW11 as well as other materials on the record, found that the retracted confession of the appellant had received ample corroboration both from direct and other circumstantial evidence, and agreeing with the sessions judge upheld the conviction of the appellant for the offence under section 302 IPC. We have considered the retracted judicial confession of the appellant carefully and analyzed the statement of learned judicial magistrate Shri Tara Singh PW1. We have referred to confessional statement in some details in earlier part of this judgment. We are satisfied that learned magistrate had taken all necessary precautions to ensure that the appellant had sufficient time to reflect before he made his confessional statement, and that he was under no fear or threat or allurement before appearing in the court to make the statement. The various questions put by learned magistrate to the appellant indicate that he had taken all reasonable precautions to remove any trace of fear from the appellant before he made the confessional statement. The testimony of the sister-in-law of the appellant, Shrimati Ratnabai, PW11, who was subjected to repeated and lengthy cross-examination in the trial court, has remained unshaken. Her statement has impressed us, and in our opinion, she had no reason to falsely implicate the appellant with such a heinous offence. Jor Singh PW12 and Bhavar Singh PW13 have lent sufficient corroboration to her testimony as well as to the confessional statement of the appellant. The only discrepancy pointed out with regard to statement of PW11 is that whereas in her statement under section 161 CRPC she had named Hansabai as the child, but at the trial she had given the name of that child as Hemraj. She satisfactorily explained the discrepancy when the question was put to her, and even otherwise one cannot lose sight of the fact that the witness had seen the most gruesome type of murder by her brother-in-law of his own wife and children. Therefore, this minor discrepancy of the name of the child would pale into insignificance, particularly when both Hansa and Hemraj were murdered by the appellant along with the others. The issue of whether a judicial officer has been actuated by an oblique motive or corrupt practice has to be determined upon a careful appraisal of the material on the record. Direct evidence of corruption may not always be forthcoming in every case involving a misconduct of this nature. A wanton breach of the governing principles of law or procedure may well be indicative in a given case of a motivated, if not reckless, disregard of legal principle. In the absence of a cogent explanation to the contrary, it is for the disciplinary authority to determine whether a pattern has emerged on the basis of which an inference that the judicial officer was actuated by extraneous considerations can be drawn. Cases involving misdemeanors of a judicial officer have to be dealt with sensitivity and care. A robust common sense must guide the disciplinary authority. At one end of the spectrum are those cases where direct evidence of a misdemeanor is available. Evidence in regard to the existence of an incriminating trail must be carefully scrutinized to determine whether an act of misconduct is established on the basis of legally acceptable evidence. Yet, in other cases, direct evidence of a decision being actuated by a corrupt motive may not be available. The issue which arises in such cases is whether there are circumstances from which an inference that extraneous considerations have actuated a judicial officer can legitimately be drawn. Such an inference cannot obviously be drawn merely from a hypothesis that a decision is erroneous. A wrong decision can yet be a bona fide error of judgment. Inadvertence is consistent with an honest error of judgment. A charge of misconduct against a judicial officer must be distinguished from a purely erroneous decision, whether on law or on fact. The legality of a judicial determination is subject to such remedies as are provided in law for testing the correctness of the determination. It is not the correctness of the verdict, but the conduct of the officer which is in question. The disciplinary authority has to determine whether there has emerged from the record one or more circumstances that indicate that the decision which forms the basis of the charge of misconduct was not an honest exercise of judicial power. The circumstances let into evidence to establish misconduct have to be sifted and evaluated with caution. The threat of disciplinary proceedings must not demotivate the honest and independent officer. Yet, on the other hand, there is a vital element of accountability to society involved in dealing with cases of misconduct. There is, on the one hand, a genuine public interest in protecting fearless and honest officers of the district judiciary from motivated criticism and attack. Equally, there is a genuine public interest in holding a person who is guilty of wrongdoing responsible for his or his actions. Neither aspect of public interest can be ignored. Both are vital to preservation of the integrity of the administration of justice. So,